Well, we're here to talk to Professor Marco Venturozzo from Penn University and Bocconi, and the idea is to talk about a little bit about your paper, very interesting paper about insider trading, and also about the legal education in Europe and United States. You have written a very interesting paper about insider trading, comparing the US and the European system. Tell us, what do you think is the main difference between the two systems?
There are lots of differences. I would probably say that the most striking one is the fact that the American approach is based on the theory of fiduciary duties. This is a fairly complex theory that makes enforcement very difficult, because basically, in order to demonstrate that there was a violation of the insider trading provisions, the SEC or the prosecutors have also to demonstrate that there was a breach of a specific fiduciary duty. Now, there are lots of other elements that should be taken into account, but this approach in itself sometimes makes enforcement very complicated, and there are lots of contradictory cases. In Europe, on the other hand, there is a more simple approach, which is called the parity of information approach, which basically states that whoever has inside information cannot trade. This approach is more straightforward, less complicated. It doesn't necessarily mean that enforcement is better in Europe than in the United States, because in fact in the United States there are lots of resources, but from a legal perspective I think this is the most important difference: fiduciary duties versus parity of information.
Thank you. That's a very interesting paper to understand Brazil, where we are in the differences about this theme. So it was very interesting to read it. And there are important changes concerning insider trading on the horizon in Europe. The Market Abuse Directive of 2003 has been overhauled with new regulation that will become effective in 2016. Could you tell us what are the major innovations?
Basic idea is to make insider trading, the scope of the prohibition of insider trading, much more broad. So in this respect, the new market abuse regulation and directive provides that also trades on certain in certain particular securities are included. Also trades over the counter are included. And also there are some additional innovations, such as, for example, including attempted insider trading. Another very important change is the fact that for the first time the European rules specifically also provide for criminal sanctions. This is really a change that will have probably a very profound impact. But basically the idea is to make insider trading broader and also to further harmonize both the sanctions and also the enforcement mechanisms, which are still somehow different in different European countries.
And you said about the criminal sanction, and I know in your paper, I discovered in your paper, a relation between human rights and insider trading that is not obvious, and it's because a case, a Grant Stevens versus Italy. Could you tell us about this case and how does it compare with this situation in the United States?
Sure. Grant Stevens against Italy is a case that was decided last year by the European Court of Human Rights, and basically states that when you cumulate administrative sanctions, such as fines or civil penalties, and criminal sanctions, which are also fines or also can be a prison term, you violate the prohibition against double jeopardy. In other words, because the same person for the same conduct is punished both with administrative sanctions and with criminal sanctions, that person is subject twice to an enforcement procedure through a adjudication, and possibly also to sanctions. And this is against a basic principle that exists in lots of jurisdictions at the constitutional level or at the statutory level, which is the prohibition against double jeopardy. This is the case in Europe, and this decision actually is very interesting because on the one hand states a principle that is correct, but also creates a challenge for enforcement because if you cannot cumulate administrative sanctions and criminal sanctions, enforcement becomes much more hard. In the United States, on the other hand, the Supreme Court had to decide basically the same question in the 1980s and 90s. And in the 1980s and 90s, to make a long story short, the American Supreme Court adopted a much more formalistic approach and basically concluded that you can have both administrative sanctions and criminal sanctions. That is not a violation of the double jeopardy provision. So in that respect, you might argue that the European Court of Justice is much more protective of the accused, while in the United States there's a stronger emphasis on enforcement and deterrence of insider trading.
Mm-hmm. So in this point, I believe we're much more
the United States
than Europe, but that's very interesting. And let's talk about legal education now. You usually teach comparative corporate law, business law. That was the challenging to have this kind of approach, and it's difficult to be brief. But where do you think that legal education is going, and what are possible future trends? Since you have, both European and the American experience, so that's something very unique.
Yeah, no, it's obviously a difficult question, but probably if I would have to underline two or three elements. One is that I think the challenge nowadays is to combine if you want, more traditional approach to legal education concerning, for example, the traditional subject matters, contracts, torts, constitutional law, civil procedure, with also the ability to integrate in a curriculum other subjects, a more interdisciplinary approach, for example, accounting or finance or economics, and the ability, in other words, to give to students not only tools that are important for interpreting and applying the law, but also to understand more broadly the economic scenario. And this is not only true with economics and accounting. Just to give another example, there are some programs, especially in the United States, but not only, that in which the focus is on law and medicine, with the idea that you have a background that allows you to represent hospitals, physicians, or people that have been injured by medical malpractice. So I think one of the trends is to really more and more be able to truly integrate law with also other subjects in a way that, however, does not become superficial. And this is one. The other, I think, trend is definitely a more international approach. The world is becoming more and more integrated. International trade and international business is more and more relevant. And in this respect, once again, I think the challenge is to combine a very solid education in your own national system, but also to give students and future lawyers the ability to interact effectively internationally. And in that respect, for both those elements, I think that in many ways it's a pleasure to be here, because FGV is really the school in Brazil that has embraced that approach and that philosophy. Then there are other things that might be interesting to consider. For example, what in the United States they call clinical education or experiential learning, which is more and more give to students with different instruments, internships, but also courses at school, the ability to deal with actual cases, with real clients, with the assistance, obviously, of a lawyer, but to involve them early on in actual problems, litigation, and so on. And those are probably three things that I think will become more and more important in the next few years.
Are you working at any specific project while here in Brazil, FGV?
I am.
What are you interested in the future relation between our law school and maybe the others?
Yeah, I mean, apart from the course, which actually is very interesting and a lot of fun. The students are truly engaged and brilliant. I am finishing this case book on comparative corporate law, and I'm writing this with some co-authors from Japan, France, Germany, the UK, Italy. But one of my goals when I'm here is to actually expand the parts on Brazil. And so I've been learning largely thanks to you and our other colleagues here, lots of things that we are trying to integrate to also enrich the comparative perspective with some ideas and rules and cases from Brazil, which, by the way, happens to be, I think, a very interesting jurisdiction because it's a system in which there are a lot of comparative perspectives. The Brazilian legislatures have often looked at other experiences, but always in a very original and unique way. So you find both rules that are somehow inspired by other systems, but also some very original and unique provisions and approaches that you find only here. And so that makes it very interesting, and I hope to be able to include that in the book.
Well, thank you very much to
Thank you.
us, and welcome to Brazil.
Thank you very much.